Hey guys, welcome to this video. This is John Watts. I'm a consumer protection lawyer. I want to shoot this very quick video before I get on the road. I have what's called a pretrial hearing today in federal court. And this is very, very typical when we have a jury trial, even without a jury trial, but normally these are jury trials, where we sit down with the judge. So it's both sides. It's the plaintiff's lawyers, that's us, and the defense lawyers, that's the company we sue. And we sit down with the judge, and we've already prepared paperwork ahead of time for the judge to consider, where we lay out typically, every judge does a little bit different, but this is the typical approach. Here are the stipulated facts. Nobody disagrees about these facts. We don't have to prove these facts. We can just tell these to the jury, okay? And what that does is it streamlines the case. We're not having to take time to prove stuff that everybody agrees to. And then we'll have sort of a summary of the claims. In other words, what is the plaintiff claiming that the defendant did wrong? What does the defendant say is their defense to what the plaintiff says? And then are there legal issues? And then we get some final deadlines. So we have things called motions in limine, okay? And that just means these are requests that we make to a judge to say, don't let the other side put evidence about this, mention this to the jury, question witnesses about something. It could be that the defendant has insurance that could pay for the case, any judgment. There's all sorts of things that can be inappropriate for a jury to hear in a particular case. And so you bring that to the judge's attention. And so that way you can get the ruling ahead of time rather than the questions asked and then the other side objects and now the judge has to figure it out on the fly. And we'll have proposed jury charges where we submit to the court, hey, here's what we think that Your Honor ought to say to the jury about negligence or wantonness or damages or whatever the theories are in the case. And then finally, usually at these things, the court will say, where are we on settlement? And sometimes they keep it very vague, hey, how are you guys on settlement? What about you guys? Other times the judge will say, tell me what number you're at. Tell me what number you're at. Okay, here's where I think you guys ought to end up. And so they use that as an opportunity to try to encourage the parties to settle the case. And then, again, it varies by judge, but typically we're trying the case to a jury in, let's say, 6 to 8, maybe 12 weeks from the time of that pretrial. So I think that maybe I've done a video on this years ago, but just thought that I would share this with you because we talk a lot about, well, here's how you figure out somebody's done something wrong. And then here are the theories you can sue them under. Here's maybe the damages you can get. Here's summary judgment, discovery, all that type of stuff. But now we're toward the end. In other words, we're very close to a jury trial on this particular case. So what happened? So I thought that this might be interesting. Okay, guys, you have a good one, and I'll talk to you tomorrow. Bye-bye.